the state's exhibits admitted into evidence? Which is what's on the state arrest.
Okay. Ladies and gentlemen, the state's rested their case, so there's some matters I need to take up with the attorney, so I'm going to have you step back into the jury room again. Again, with your notepads, go ahead and flip them over to that first page. If you'd like to go outside, just let the court deputy know, but that same instruction continues to apply that you cannot yet discuss the facts of the case, okay? Thank you. One thing I do want to address briefly, Mr. Ackerman, I had made a ruling about the photographs. You may not have agreed with it, and I understand, but you intentionally got up there at the podium and asked the medical examiner those questions about the photographs that I had previously ruled on, and that's not appropriate to do. I'm going to ask you, do you not do that moving forward? If I make a ruling about an exhibit coming in, whether you agree or disagree, that's fine, but you cannot then go ask questions in, complete disregard for my ruling.
Your Honor, may I? Your ruling, as I saw it, was allowing the photographs in. And I understand that perfectly, and my questions had nothing to do with the actual ruling. My question has to do with the way I am developing my defense. I have a strong defense. I have a client who's not guilty, and I am trying to show the jury in closing arguments, etc., where the state's case failed, where they haven't made their burden of proof, and how they've been manipulated, and how they've been. So my question to the doctor, the state's question was, will this assist you? And my question had nothing to do with it. I understand that. I'm not saying, all I'm asking her is, would you read those photographs to articulate what you did, how you testified to the jury about pictures? And then I can make a comment on it in closing argument. Because to me, they were totally unnecessary. That doesn't mean you let them in.
Because the case law supports them coming in, and I made the ruling, Ms. Jensen's question to her was, will these assist you in explaining to the jury? And her answer was yes.
And my question was.
Okay, Mr. Ackerman, I've made my point. We don't need any further discussion on this issue.
Well, let me ask this.
No, sir, I'm going to ask that you have a seat. I'm going to ask that you just have a seat, and we're going to discuss the plan moving forward with the remainder of the trial. All right, the state has rested their case. My understanding is you don't have any witnesses available today if you decide to put on a case. Is that correct?
That's correct.
Okay. Have you discussed with Ms. Agee whether she intends to testify?
I have.
Okay. Would you like me to do an inquiry now, or give you some more time to talk about it tonight and do the inquiry in the morning?
Hold on.
Okay. Any other matters then that the court needs to address? Otherwise, we can maybe talk about jury instructions preliminarily.
I just want to make sure that our Martinez is here now, in case it's needed.
Okay. I don't have anything to do with that. I just let him know he remains under subpoena. You can certainly discuss that with Mr. Myers and Ms. Jensen. But I hope you understand, I know you asked him a question about could he do particular research. That doesn't mean he has to or is going to go do that research tonight. I assume you are aware of that.
Hopefully we can work that out.
Okay. All right. Anything else then from the defense?
Can I wait until tomorrow to make my motion for judgment of the first? What do you want?
I think let's move forward and address it now.
The state has made a complete and total case for the murder of Brooklyn by Keith. So obviously, all that evidence today went to what Keith did. The only evidence that the state has against Sheila is that video. The defense argues that any reasonable group of people who would view that video would see the sarcasm, the innuendo, based on the statements, the responses, the statements back, and see what would have to, if they don't see, would have to have a reasonable doubt as to whether or not she had the intent that her son killed another human being. Everything on that video, except for the 4 or 5 things the state points out, and there are 10 or 15 other things along with those things the state points out that show the sarcasm. Hey, don't wait for us to come home, do it here. What, are you an idiot? What, are you gonna do this? Don't shoot at the car. You might hit me, son. You wanna hit your mother? You think about this. You're out there, you're gone. And she says it. You have mental issues. You have, and I could go on, I think the video speaks for itself. Erase this thing. This is stupid. Don't you see, son? If you think about what you just said, and it's in paper. Anyway, the fact that she erased her phone. Well, we don't know what in the world that was about. She may have erased it to save him so that no one could see. We don't know that she was thinking of herself. And everything else, if you don't kill the bitch, if you don't kill her, you're a bitch. Well, just before that, I'm not gonna help you get in trouble. And just after that, he comes back with, well, she did this to me, she did that to me. He knows that she's talking him out of it. Now, whether he's capable of being talked out of it or not, but any reasonable group of people have to look at that and say, I have a reasonable doubt. My goodness, this is crazy. This is what a mother is telling her son so that he will not hurt himself or others. You say that the state has failed to make a crime evasion case. They have not proven intent, that she intended for the acts to take place. Thank you.
Okay, thank you, Mr. Ackerman. Ms. Jensen.
Judge, Mr. Ackerman said the only evidence that the state has is the video. The state presented over 2 hours of text messages. This defendant directed her homicidal son away from Alabama, 90 minutes away, to Pensacola, Florida, and provided an address where he could find Brooklyn Sims and come and kill her. The state believes it is presented a prima facie case, and the court should deny the JOA.
Your Honor, if I misspoke, if I said video, I meant the text. I hope everybody knew that. And the fact is, he was not 90 minutes away from Alabama, he was 90 minutes away from Pensacola, which furthers the point. You'll have time to drive here and think about it. Nice long drive, calm you down. Any reasonable person would think that rather than up there. Any reasonable person listening to those texts would say, she's using this, anyway, she's trying to convince him not to do this. She said 10 times, you don't want to do this. You don't want to do this. You'll go to jail. You'll have a granddaughter. You'll have a daughter. My granddaughter will be left without a father and a mother. She'll commit suicide. Who are you going to take? What are you doing, son? Thank you, Joe.
Okay, thank you. Again, viewing the evidence in light most favorable to the state, believe they presented a prima facie case of principle of first degree premeditated murder, and the matter should go to the jury. Someone denied the motion for judgment of acquittal. Mr. Ackerman, just for planning purposes, in addition to obviously talking to your client tonight, do you know at this time how many other witnesses you might present tomorrow?
3, maybe 4.
In addition to potentially your client?
Yes.
Okay, so maybe up to 5. Okay,
Or some Jack, or Mother Thelma, possibly Keith, and possibly Martinez.
Martinez. Okay. Then I think we can go ahead and bring the jury back in and release them for the remainder of today and let them know that we plan to reconvene at 8:45 for court personnel, 9 a.m. for trial, and then we can stay and look at the jury instructions at least on a preliminary basis, and then recess for the evening unless there's any other matters we need to discuss.
I have talked to the state judge, and we have discussed if in the event she does testify, they will not be asking her about her prior record, so that's not an issue. I wouldn't be asking for that.
Does she have a prior record that's,
From 20 years ago.
okay, so no felony convictions or crimes involving dishonesty that would be,
Nothing the state intends to use it.
okay. Any of the other witnesses that are potentially going to be called that we need to talk about prior record,
Just to keep Agee.
if he testifies?
We deposed her mother and her other son, and I don't know, obviously, Mr. Ackerman, where he's gonna go with the witnesses necessarily, but there was a lot of objectionable evidence or testimony in the depositions that we don't believe would be admissible. So just so the court's aware, we may be dealing with that tomorrow.
Okay. Well, we can certainly address any further matters. I'm going to go ahead and bring the jury in so they can be released for the evening.
Yeah.
Okay. We can have that.